Americans own more guns than anybody else on Earth.
Illinois state lawmakers are moving forward with the plan to ban assault weapons.
Thank you, Nick. Developing this morning, it's been 1 month since registration opened under the Protect Illinois Communities Act.
The reality is that the state police is responsible for enforcement.
A high-stakes court struggle has surrounded the Illinois assault weapon prohibition, which started with tight limits on certain rifles and magazines under the Protect Illinois Communities Act, or PIKA. The issue concerns not just Illinois' gun regulations, but also individual rights, state authority, and how the law is interpreted, all of which have an impact on us. The U.S. has an epidemic of gun violence that has embarrassed the entire world.
Breaking news out of Texas, and it is heartbreaking.
An active shooter situation has occurred. 3 young children and a woman.
California, Oklahoma,
Virginia.
AR-15.
A shooting. Another one.
A teenage girl and a young woman died.
We are once again talking about gun violence in America.
The third highest rate of gun-related injuries in the nation is 90% higher. The Illinois ban affects not just firearms, but also the limits of state and federal jurisdiction.
Val and Terrell lawmakers tweaked the original bill they had on the table, and shortly after midnight, the modified ban on high-powered weapons and large-capacity magazines.
A bureaucrat's sovereign decision to make millions of Americans felons is at the center of this situation, notwithstanding the state's efforts to restrict access to particular rifles and magazines. The Second Amendment restricted who was allowed to acquire certain types of weapons from the day it was passed, contributing to the plague of gun violence in the U.S. and its international shame. The prohibition includes a registration deadline, with gun owners having until January 2024 to register prohibited weapons, in addition to outlawing specific rifles and standard magazines. This deadline intensifies the already contentious discussion over defunding the police and trying to charge gunmen with crimes. The Illinois state, at the center of this restriction, has made a shocking announcement. Unless instructed to do so by the high-ranking justices on the Supreme Court, they would not defend the ban. This implies that the Supreme Court is in complete control and may determine whether or not this prohibition is upheld and if it is legible. The Illinois' attack weapon prohibition is in the middle of a judicial battle, and its future is up in the air. The Supreme Court has the authority to determine whether the prohibition is upheld or repealed, notwithstanding the state's unwillingness to defend its laws.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
Our Second Amendment. It's a hell no to government trampling on our freedom.
We're outmanned, we're outstaffed. We do need responsible gun legislation.
Directly attack the issue you have. And for me, very laser focused. It's vital crime prevention.
We have the third highest gun-related injuries in the country, 90% higher.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Second Amendment protects firearms in common use at the time, and also said this, quote, for lawful purposes like self-defense.
The state of Illinois is now claiming that it will wait to intervene in this case unless the Supreme Court does so, allowing the Supreme Court to decide whether to uphold the prohibition or not. The Illinois Supreme Court will have to determine whether to maintain or lift the prohibition on specific types of guns and magazines. This ruling has sparked controversy and established a precedent regarding the Supreme Court's jurisdiction in cases involving conflicts between state legislation and constitutional rights. It raises questions and ignites arguments when Illinois refuses to stand by its own laws. It's like throwing a curveball into the judicial system. A lower Illinois court's declaration that the restriction was illegal sparked a legal fight that shocked the legal community. But in a razor-thin ruling, the Illinois Supreme Court decided, 4 votes to 3, that the prohibition remains in place.
And we are following breaking news from the Illinois Supreme Court, which just ruled the state's ban on assault weapons is constitutional.
The Illinois Supreme Court upheld the state's ban on assault weapons. It was a 4-3 vote. Earlier this year, the justices upheld temporarily a new state law.
The legal system's checks and balances, the judicial process, and how various courts interpret the law have all come under scrutiny in the wake of this ruling. Judicial impartiality issues have been the main source of fuel for the discussions surrounding this case. Two Illinois Supreme Court judges, who will play a significant role in determining the outcome of the ban, have made it known that they support prohibitions that are comparable to the one that is being discussed in court. Before the issue ever made it to court, they waved the ban flag in support of bans like the one that is currently being discussed in court. Due to reservations about the judge's objectivity, a move was made to remove them from the decision-making process about the ban. They contend that since these weapons are often used for legal reasons, they are protected by the Second Amendment. However, the court shut down the disqualification motion, saying that there was no need to step aside, and those judges stayed put, right in the thick of the ban debate. Nevertheless, the court dismissed the disqualification request, ruling that the judges should remain in the middle of the ban discussion and that there is no reason for them to stand down. People are left wondering how these judges, with their past affiliations and leanings, could stay impartial in a case of such importance as a result of the legal tug-of-war between worries about justice and the court's decision to maintain the justices in the case. Not only is the prohibition itself at issue, but also the public's confidence in the justice system and the assurance that rulings rendered by high courts are genuinely impartial and fair. The argument made by petitioners is that the prohibited weapons are actually instruments used by law-abiding individuals, not merely beautiful toys. They contend that since these weapons are often used for legitimate reasons, the restriction violates the Second Amendment. They are, however, not content to stop at Second Amendment rights. They intend to hit the Supreme Court with yet another surprise. In addition, the Illinois Supreme Court's ruling to postpone the prohibition on specific weapons and magazines was reached after a difficult and drawn-out judicial dispute. The public's confidence in the legal system, the judicial system, and the system's checks and balances have all been called into doubt. The future of gun legislation and gun owners' rights will continue to be shaped by the continuous discussions around this topic. There is a rift among Americans over the country's prohibition on the sale of guns, with some urging its repeal. According to the Supreme Court, each person has the right to bear weapons under the Second Amendment, but only at home in areas like Florida, where people are allowed to carry guns. Since various states are not permitted to enjoy the same rights under the law, this gives the impression that individuals are being treated unfairly and unevenly. The registration deadline, which is scheduled to blow in January 2024, is another aspect of the prohibition in addition to prohibiting certain weaponry. Because it separates those who can fulfill the deadline from those who cannot, this timetable does not treat everyone fairly. Due to this division, there are now two types of citizens: those whose rights are unaffected and those whose rights are in jeopardy. Discussions over justice and whether or not state laws should favor people's rights have been triggered by this judicial standstill. Illinois wrote the U.S. Supreme Court a letter stating that they would wait for them to rule otherwise in this legal dispute. This is viewed as a calculated action that puts the Supreme Court in complete control of the decision-making process. Illinois is waiting on the Supreme Court to rule in their case, so they are essentially playing a waiting game. Unless the Supreme Court comes knocking at their door, they are not exactly itching to get into a response game. Illinois is requesting that the Supreme Court require a response, which is akin to a calculated delay in a game of legal chess. Legal experts are scratching their brains over this decision and wondering what will happen next. It's similar to Illinois, stating that until the Supreme Court raises an eyebrow and makes a demand, they will not defend their legislation or offer their version of events. Everyone is waiting impatiently to see how this calculated maneuver will turn out in the suspenseful judicial drama. There's a lot of build-up to this moment, similar to a tense courtroom before the judge steps in. There's talk that Illinois may not be out of the woods, even though they're playing chicken and taking a back seat in this court battle. Furthermore, The United States' restriction on the sale of weapons has sparked a judicial battle that has left everyone doubting the ban's justice. The problem is not limited to firearms. Equity and justice are also at stake. There is a lot of buzz in the legal community about what action the Supreme Court may take next. The Illinois restriction on certain handguns and standard magazines is creating a legal maze that involves Second Amendment rights in addition to state law versus individual rights. Since before the country's inception, there has been a widespread use of firearms, and hundreds of incidents use weapons that are not prohibited by this law. Illinois is engaging in a calculated game of wait and see, and the Supreme Court may respond. Everyone is holding their breath in anticipation of the Supreme Court's decision to investigate this prohibition in more detail, and the tension is tangible. Though historically, the Supreme Court has favored letting subordinate courts take the lead before becoming involved, this case has generated curiosity and rumors that the court may move in sooner than normal. The consequences and weight of the implications are too high on stakes to just sit back and take it all in. Legal experts are examining earlier rulings to detect any hints that may point to a shift in the Supreme Court's philosophy. The Illinois ban case is more than simply a standard legal dispute. It has the ability to alter the course of legal history and force the Supreme Court to rewrite its playbook and enter the legal arena earlier than expected. That will bring us to the end of this video. Subscribe to our channel for interesting videos about shotguns, handguns, and gun control-related news videos.